Again, this is Terry Bankert, WFLT 1420 AM radio. The call-in station number here is 239-5733. This will be YouTube and posted on my website. You go to attorneybankert.com, Google it, go to writings. You'll see the post for the information today, and hopefully by noon you're going to see a video of what I'm doing right now. What we're going to talk about today is a real-time case, meaning hot off the presses is what it is. In this particular case is out of Washtenaw Circuit Court. It was released by the Michigan Court of Appeals on 12/20/07. So this is a new release. It is for the people that follow this. It's an unpublished case, but it's the same Court of Appeals and it's the same law. And the case name here is Rasmussen versus Casamata. And what's interesting here, dads, I want you to listen up. This is where an out-of-state dad got custody of the children. And we're going to talk a little bit about that. So it is feasible. Again, just to back up, divorces are started by filing a complaint for divorce in the proper county where the children live, mom lives, or dad lives. And you have to be a resident in the state of Michigan for 6 months. You have to be in the county for 10 days. So if somebody moves within Michigan, 10 days later they can file in another city. Then when this complaint is filed, the opposing party, mom or dad, whichever one, files an answer. And then there's a 6-month waiting period in cases with children. Obviously it's shorter if there's no children. It's only 60 days. There's a 6-month waiting period. So then the question becomes, what do you do in that period between when somebody files and when the judge decides or you agree to enter a judgment of divorce? And of course, we're not advocating divorce here. It's just a reality of what's going on in our society. Always talk to your pastor, always talk to a counselor, seek out the support of family members, and give it that second try before you do. But if you find yourself in this situation and you have children, then the question becomes, what happens to the children and the bills and the marital home for that 6-month waiting period? So where you will find yourself then is in front of the court before your 6 months is up. And you need to go talk to the court to get some direction and control over these things concerning the children and bills. And that's called a temporary order. Temporary meaning that it only exists between the time you file and the time the judgment's entered, unless it's characterized as something else. It can be characterized as a permanent order, but normally they're just temporary orders. And it says what's going to happen to the children. And what I tell my clients is that you have to be, this battle occurs on the front side in terms of children, because these temporary orders become permanent real quick. And you're going to go to court within a couple weeks of having filed. And you're going to ask the court to make a decision on what's going to happen with these children. And how do you ask the court to do something? You file a motion. How does the court make a decision? It has a hearing and other things. And then what is the court's final decision? Well, in the judgment of divorce, it's a judgment. As to these temporary things, it's called an order. And here's where I'm going with this. Mom had a temporary order that gave her custody of the children. And they went to trial. Now, this is not a county court, so I can talk pretty liberally about it, because I know I'm not going to immediately offend a local judge, and I'm not going to know the parties, and of course we never mention the names of children's here. But I can, since I know there's this 6-month waiting period, Mom had this temporary order for 6 months. But Dad got out-of-state, father got custody of the children, and here's why. Because Mom's life was so unstable that the custodial environment, that's a key word, wasn't created solely with her. She involved a lot of other people with these children. She was moving them around, doing a lot of things. And so out-of-state father came in. Dad had to move, I believe, probably employment related, but out-of-state father then came in and with the proper argument got custody of these children. So it's not a foregone conclusion. It's not completely set in stone. but be very, very careful. So we're going to talk about these temporary orders to begin with. One, family members, you go with your young men to court on these issues. Men, you have a right to have joint custody. You have a right to have parenting time. Don't treat these temporary orders as just a temporary thing, because they become permanent really quick. So in this case called Rasmussen out of Washtenaw Circuit Court, Dad was out of state, but the court decided that no custodial estate was created. And that took some aggressive pleading and trial preparation and trial presentation on the part of Dad and his attorney. You need to know that you can fight for your rights, dads, but you've got to stand up to it and meet the burden of showing that mom doesn't have that custodial environment. You need to stay in touch with your children. You need to stay in touch with their teachers. Be involved in the medical decisions and the healthcare decisions of your children. Create that custodial environment. Now I'm YouTubing this, and I'm going to do this in about 5 or 6 minute breaks. My name is Terry Bankert. This is WFLT 1420 AM radio, and this is my weekly program, Know the Law.